As parents, we make one of the biggest decisions of our day in just a few seconds. We buckle our child into the car, walk them into daycare, hand them over to someone else, and trust they'll be safe. But what happens when that trust is broken? A recent lawsuit alleges that a child care worker threw a toddler into the air, failed to catch him, and the child suffered a traumatic brain injury. Beyond the shocking allegations, the case raises an important legal question. When someone else is responsible for your child's safety, what duties do they owe? And who can be held accountable if something goes terribly wrong? I'm Eric Bartlett, 29-year personal injury lawyer. This is the Injury Law Pod, the podcast where we talk about all things personal injury law related, and we pull from the headlines and we talk about your legal rights. So let's dive in. Today, we're discussing the allegations behind the California child care lawsuit, the legal duties child care providers owe children, when an employee may be personally responsible, when the daycare, school, gym, church, camp, or larger organization may also be liable, why brain injuries in very young children can be difficult to recognize, the mistakes organizations sometimes make after a child is hurt, and what parents should do immediately after a serious child care injury. So, breaking down this current lawsuit in California, according to the allegations, a 23-month-old child was in a child care program operated inside a fitness club. Surveillance video allegedly shows an employee swinging the toddler and throwing him into the air. The employee allegedly failed to catch the child. The toddler reportedly struck the floor. The child was later diagnosed with a traumatic brain injury. The family alleges they were initially given an explanation that did not accurately describe what happened. And the larger business operating the facility has said it cannot comment on pending litigation and that safety is a priority for them. Now, we have to keep in mind these are allegations in a civil lawsuit. The defendants have not had their full opportunity to present evidence, and the facts will ultimately be determined through the legal process. But regardless of how this individual case is ultimately decided, it raises questions every parent should understand. When we leave a child with a daycare or a school, a camp, a church, a gym, a babysitter, or a youth organization, what legal responsibilities come with accepting that child into their care? So, what duty does a child care provider owe? Children, especially toddlers, cannot fully recognize danger or protect themselves. I think we all understand that. That is why child care providers accept a significant responsibility when they take custody of a child. The basic responsibility is that a child care provider is expected to use reasonable care under the circumstances. And that can include proper supervision, age appropriate activities, safe handling of children, safe facilities, adequate staffing, qualified and trained employees, emergency procedures in place, prompt medical attention if something does happen, accurate communication with parents, and compliance with licensing and safety rules. The younger the child, the greater the need for supervision. A toddler may not be able to explain how an injury happened, identify who was involved, describe symptoms, recognize unsafe conduct, ask for medical help, or protect against rough handling. A 2-year-old cannot evaluate risk, refuse an unsafe activity, or give a clear account of what happened. The adults responsible for that child have to do those things for them. Now, responsible care does not mean perfect safety. Children fall, children trip, children collide during play. Not every injury creates a claim. Not every injury creates a lawsuit. The question is whether the injury resulted from an unavoidable childhood accident, a momentary lapse that was not legally unreasonable, inadequate supervision, unsafe conduct, a dangerous condition, or a failure to follow proper procedures. The law does not require child care providers to guarantee that no child will ever get hurt. It does require them to act reasonably when protecting children who cannot protect themselves. Understanding the duty owed to a child is only the first part of the analysis when you're looking at some kind of a child care situation. When a serious injury occurs, parents naturally focus on the person who is physically present, but responsibility may extend much further. The employee may be involved, but so may the daycare, the company operating the program, the property owner, or another organization that hired, trained, supervised, or controlled the people responsible for the child. So let's break down the bigger question: who can actually be held responsible when a child is hurt at a daycare? When a child is seriously injured at a daycare, most parents immediately ask one question: who is responsible? The obvious answer may seem to be the employee who was with the child at the time. But serious child care cases often involve a much larger investigation. Depending on what happened, responsibility could potentially include the individual worker, the daycare, a larger parent company, the property owner, or even the manufacturer of defective equipment. Today, we're breaking down the parties that may be legally responsible when a child is hurt while someone else is supposed to be keeping them safe. So let's start with the most obvious: the individual employee. An employee may be directly responsible for his or her own conduct. Examples of that would include rough handling, unsafe horseplay, improper restraint, physical discipline, leaving a child unattended, ignoring medical distress, allowing an obviously dangerous activity to occur, failing to follow basic safety procedures, and the worst situation is some kind of physical assault by the employee on the child. A key question when looking at this particular person: was the employee acting negligently, recklessly, or intentionally? Those distinctions may affect the legal claims, insurance coverage, punitive damages, or whether the employer is also responsible. Now, if we move on beyond that individual employee and we go to the next step, the daycare or the child care operator, the business operating the child care program may be responsible for more than the employee's immediate conduct. Questions include: was the employee properly screened? Was a background check performed? Was the employee trained? Were there prior complaints about that employee? Was the worker qualified to supervise toddlers? Was the staffing ratio appropriate? Were the policies that the daycare had in place enforced? Was there proper supervision of the employee? Did management ignore warning signs? And did the facility comply with licensing requirements? A child care facility cannot simply hire someone, place that person in a room with toddlers, and then claim the employee acted alone. The organization's own hiring, training, supervision, and safety practices may be part of the case. Then we move on to a potentially larger parent organization. In this particular news story that I referenced previously, the child care program was reportedly connected to a larger fitness organization. And that's something that's common. A lot of fitness centers offer in house daycare for the parents that are going to work out. This raises questions about corporate responsibility. The larger organization may be involved if it employed the worker, operated the child care program, controlled policies, hired or supervised managers, established safety procedures, controlled the staffing, received complaints previously, and marketed child care as part of its services. But there is an important distinction to make. A business may not avoid responsibility merely by calling the childcare area a separate department or program. The legal analysis often examines who controlled the operation, who employed the staff, who created the rules, who profited from the service, and who had the authority to correct problems. Now, if we even span wider on the potential people responsible or business entities, we can look at the property owner. Sometimes the child care provider operates on property that's owned by someone else, and the property owner may be involved if the injury resulted from dangerous flooring, broken stairs, unsafe playground equipment, poorly maintained gates, defective doors, exposed electrical hazards, swimming pools, dangerous parking lots, or inadequate lighting. Responsibility may depend on who controlled the area, who maintained it, who knew about the condition, and what the lease or operating agreement required. Obviously, the more control that a landowner has over a particular part of the property, and if that part of the property was involved in injuring the child, the more likely the property owner has responsibility for an injury. Now, even looking further in the scope of potential people or businesses that are responsible, an equipment or product manufacturer could be involved. Some childcare injuries are caused or worsened by defective products. For example, cribs, high chairs, changing tables, playground equipment, gates, toys, car seats, sleep products, restraint devices. Potential questions that might be relevant to a product or equipment manufacturer include: was the product defectively designed? Was it improperly manufactured? Were there adequate warnings provided about the equipment? Was the product ever recalled? Was it being used as intended? And did the child care facility maintain it properly? Now, a lot of times in these situations, there are multiple responsible parties. So it doesn't just end with the employee, and it may not just end with the employee's employer. There, again, may be multiple people responsible. A single incident may involve several different failures. For example, an employee engages in unsafe conduct, but the daycare failed to train the employee, and management ignored earlier complaints. The larger company over management failed to enforce its policies, and there's video evidence that was not immediately preserved. When a child is seriously injured, it is rarely enough to ask who was standing closest. The better question is who accepted responsibility for keeping that child safe. Identifying the possible defendants is only part of the case. The next challenge is understanding the injury itself. That is especially important when the child is too young to explain what hurts, what feels different, or how the injury is affecting everyday life. Brain injuries in toddlers can be particularly difficult because some of the most serious consequences may not become obvious right away. So let's talk about why brain injuries in young children are so difficult. A traumatic brain injury does not always look dramatic. A child may not lose consciousness. They may not have a visible wound. Initial imaging may not tell the full story. Possible early symptoms of some type of a traumatic brain injury include parents noticing vomiting, excessive sleepiness, irritability, balance problems, unusual crying, loss of appetite, difficulty waking, changes in their speech, confusion, sensitivity to light or sound, and seizure type activity. And here in our practice, we've seen a lot of that with children where something happens and then the parents start noticing some patterns developing in what's going on with their child. Something is just not right. But problems that may emerge later as the child develops, additional concerns may appear. Speech delays, learning difficulties, attention problems, memory issues, behavioral changes, emotional regulation problems, motor skill delays, headaches, sleep disruption, or vision and hearing issues. A very young child has not yet reached many developmental milestones. That means doctors and families may not immediately know whether the injury will affect their reading, executive functions, social skills, school performance, emotional control, or future independence. With a toddler's brain injury, the full impact may not be measured by what the child lost today. It may be measured by what the child struggles to develop tomorrow. This is why long term follow up matters. Depending on the injury, care may involve pediatric neurology, neuropsychological testing, physical therapy, occupational therapy, speech therapy, behavioral therapy, developmental assessments, educational support, and future care planning. Now, the upside to all of this is that when you're dealing with a child, the legal time limits that are involved are greatly extended. So most of the time, I can tell you, Missouri, Kansas, that a minor has a lot of time to present their case, either to get it on file as a lawsuit or get it resolved. And so it does allow for the full development of problems, treatments, what the future looks like to really develop before a legal side has to conclude. Now, having said that, and as I always say, waiting to do anything at all is not a good plan of action because, again, you've got to secure evidence and put people on notice and all those types of things. But when it comes to the child's injury and what treatment's going to look like, what problems they're going to have, what the future holds, there's plenty of time to let that part of it unfold and really get a good medical understanding of their injury. So, a lot of times in these types of cases, we see mistakes that organizations make after a child is hurt. The response after an injury can become almost as important as the incident itself. And here's why. A lot of times, the business wants to minimize the event. For example, he just bumped his head. She seems fine. It was a normal playground fall. These are things parents might hear when they're notified about the injury. A serious injury should not be minimized before the child receives appropriate evaluation. They also sometimes delay medical attention. When a child shows concerning symptoms, a delay can worsen the medical risk, delay diagnosis, cause parents to lose trust, and create questions about the organization's policies. Another mistake that is made by these businesses, giving parents incomplete or inaccurate information. Parents need to know what happened, when it happened, who was present, what symptoms appeared, what first aid was given, whether emergency services were contacted, and whether video exists of the incident. Parents can handle bad news. What they cannot handle is discovering that they were not told the truth about what happened to their child. Another mistake that these businesses sometimes make is that important evidence may include surveillance video, incident reports, employee schedules, staffing records, text messages, internal emails, training materials, prior complaints, licensing records, and witness statements. Video systems may automatically overwrite recordings. And this is why preservation requests can be crucial. A lot of times, these businesses, they're not on their own going to take the proper steps to make sure everything surrounding this incident is properly preserved. And that's why it's critical if your child is injured while under the care of someone else that you are taking the necessary steps to make sure they're on notice to preserve everything that could be potentially important, could be potential evidence for this claim. Finally, businesses oftentimes they focus on the liability instead of the child. Something happens and A business freaks out. They get nervous, right? Now all of a sudden they're worried about what their exposure is and what this is going to look like. And they become defensive immediately. And the first concern should be the child's condition, emergency medical care, honest communication, preserving evidence, and preventing another injury. But unfortunately, in our world, it doesn't always go that way. And that's why, if you're a parent and your child has been hurt in a situation like this, unfortunately, I think it's more of the trust but verify logic. Maybe it's not even trust. You need to take the appropriate actions to make sure you're able to hold them accountable down the road. So, what should parents do after a serious daycare injury? Number one, obviously seek appropriate medical care. Do not rely solely on the child care provider's assessment. If the child has concerning symptoms, obtain immediate medical evaluation. Ask for a complete explanation from the business, from the daycare, the camp, whatever the organization is. Request a written incident report, the names of the employees that were present, names of any witnesses, the precise time of the incident, what first aid was provided, whether emergency services were considered, and whether surveillance video exists. That video can really be a critical piece of evidence. I can't emphasize that enough. You need to document the child's condition. Take photographs of any bruising, swelling, cuts, any other visible injuries if they're there. Keep notes about vomiting, sleep changes, behavior changes, speech changes, balance problems, appetite, pain complaints, missed school or missed activities, anything that's not tracking with how you know your child normally behaves, how they normally act, and how they normally are. Ask in writing that the facility preserve video, incident reports, staff schedules, training records, internal communications, photographs, licensing documents, and prior complaints involving the employee or the condition, whatever it is that's involved in this incident. And again, unfortunately, yes, the parent should do that in writing, but a lot of times this is where a lawyer is going to provide value, because when somebody gets a letter from a lawyer, that tends to get more attention. Let's just be honest about it. And so, again, I can't stress enough, you get somebody that knows these cases, a lawyer, they've dealt with them, they know what they're looking for, and they know how to put the company and anybody else that might be responsible on notice. Here's the other big thing to keep in mind: avoid rushing into a recorded statement or any kind of a release, any kind of paperwork. An insurance company may contact the family quickly. If the company turns it into their insurance company, that insurance company will go to work evaluating this claim. Before the full nature of the injury is known, parents should be cautious about recorded statements. Matter of fact, I always say just don't do recorded statements. Sure, you can tell them what you know, and unfortunately, you may not know very much, and that's critical to emphasize. You only know what you're being told, probably. So, no recorded statements. You can tell them what you know, what you're seeing with your child, things like that. Medical authorizations, again, I'm always telling people don't sign an insurance company's medical authorization, because that just gives them an open ended authorization to get any medical records on your child from anywhere for any period of time. Quick settlement offers, always a red flag. Again, in the car accident world, we see this a lot now, where insurance companies, within a couple weeks of an accident, they're calling the person that was injured and trying to make them some lowball quick offer. And again, you always have to think, who's really benefiting from something like this? Is it me taking a low offer when I don't even know the full extent of an injury? Or is it the insurance company? So keep that in mind. Ignore early, quick settlement offers. And then releases of all claims. Again, if an insurance company is wanting you to sign a release of the claim, you have to remember this: that release is forever. And again, if you don't know the full extent of your child's injuries and what this is going to look like, you could be forever concluding the claim without making sure your child is fully taken care of. Report serious concerns to the proper agency. Depending on the facts, this may include child care licensing authorities, law enforcement, child protective services, the organization's corporate office, a school or church governing body. So it's very important. Get proper agencies involved. And then, as I've already indicated, speak with an attorney when the injury is serious. Speak with a seasoned personal injury lawyer, someone that has dealt with these types of situations before. The purpose is not simply to go and file a lawsuit. Unfortunately, people think you get a lawyer involved, all of a sudden we're lawsuit filing people, and that's absolutely not true. Okay, you have to remember, just because you're getting a lawyer involved doesn't mean there's going to be a lawsuit necessarily. But an attorney can help preserve that evidence, identify responsible parties, obtain video and records, investigate prior complaints, coordinate medical documentation, evaluate future needs, and protect the child's legal rights. So, the larger lesson to all of this is trust creates responsibility. This issue extends far beyond traditional daycare centers. Daycares are a big one because, again, their whole job structure is around taking care of kids. But in parents, they entrust their children to schools, churches, youth sports leagues, summer camps, gyms, after school programs, babysitters, transportation services, dance studios, martial arts programs, and community organizations. Each setting may involve different rules and relationships, but the central question remains: who accepted responsibility for the child, and what did reasonable care require under those circumstances? When an organization asks parents to trust it with their children, that trust is just not emotional, it carries real responsibility. So, as parents, we cannot eliminate every risk our children face. Children will fall, they'll bump their heads, and sometimes they'll get hurt despite everyone doing the right thing. But when we place a child in someone else's care, we have the right to expect reasonable supervision, safe treatment, prompt medical attention, and honest communication. Cases like this one that's going on in California remind us that trust carries responsibility. And when that responsibility is violated, the law may provide a path to accountability. If your child has been seriously injured at a daycare or school, a camp, church, a sports program, a gym, or another place where someone else was responsible for their care, you don't have to figure it out alone. Here at Northland Injury Law, we've seen many of these types of cases involving children over the years. We've been there and we've done it. And we help families understand their rights, we preserve important evidence, and we investigate what really happened. If you have questions, we're here to help with a free consultation. Anytime you can call us, you can reach out on our website. But until next time, hug your kids a little tighter, stay informed, and thanks for listening to the Injury Law Pod.